Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148 which can help maximum number of the employees in contesting the notice under section 148 on the jurisdictional grounds, on the technical grounds. As we have seen that the section 148 notices are issued in a very casual manner and bypassing the basic ingredient of section 148, that the assessing officer has reason to believe that the income has escaped assessment, and this recording of reasons to believe should not be arbitrary, should not be tempted by whims and wishes, and it is possible only when the assessing officer does his homework before issuing the notice under section 148. In the present case, the plea of the assessee before the Amritsar tribunal was that if the assessing officer has not mentioned in the notice that whether the assessee has filed the return or not, so in the absence of this finding by the assessing officer, can it be said that the assessing officer has reason to believe that the income of the assessee has escaped assessment, and due to which he is issuing the notice under section 148. This issue has been taken by Amritsar Tribunal in the case of Darshan Garg, Hindu undivided family versus Assistant Commissioner of Income Tax, and this case has been reported in 113 ITAT Tribunal, short note 718. The date of the judgment is 1st July 2024. In the present case, the notice issued to the assessee and the reasons supplied to the assessee didn't mention that whether the assessee has filed the return of income or not, and the assessee was challenging this notice on the ground that without recording this finding in the reasons, how the assessing officer can live link the information with the allegation that the income has escaped assessment. There are a number of cases where the notices have been quashed on the basis that the notice under section 148 has been issued on the wrong facts. So whether in the present case, if it is not mentioned in the notice that the assessee has not filed or filed the return of income, so whether this can be said that the notice has been issued on wrong facts. So in the present case, the tribunal said that the factor of not filing the return weighted the assessing officer for arriving at the satisfaction about the failure on the part of the assessee and escapement of income. Apart from these, various notices have been quashed where the notices have been issued on wrong facts, like in the case of Sagar Enterprises versus Assistant Commissioner of Income Tax, which has been decided by Gujarat High Court in 2002, where in the reasons it was alleged that the notice has been issued because the assessee has not filed the return of income, while in actual the assessee has filed the return of income. So the notice was quashed on wrong facts. And in the second case, which was relied by the tribunal, is Gaurav Joshi versus Income Tax Officer, which has been decided by Amritsar ITAT, in which the reasons alleged that the cash deposit is 1.39 crore and in actual the addition was made of 51 lakh. So in that case also the tribunal quashed the notice by giving the reason that the notice has been issued on wrong facts. And in the third very important case, that is Fortune Meta Lex Limited versus Deputy Commissioner of Income Tax, which has been decided by Chandigarh ITAT, in which it was alleged against the assessee that the assessee has purchased from bogus entities and the purchases were made from two parties, while in actual one party was mentioned wrong and the amount alleged was also wrong. So in that case also the notices were quashed on the basis of wrong facts. The crux of the theory is that if the reasons do not mention that whether the return is filed or not, it was the viewpoint of the tribunal that the factor of not filing of the return of income must have been there in the mind of the AO, and which have weighted the assessing officer for not or for arriving at the satisfaction about the failure on the part of the assessee and escapement of income. So friends, the crux of the case is that if the reasons do not mention that whether the assessee has filed the return of income or not before issuing the notice under section 148, then in that case the notice can be challenged on this ground also. At the end of this video, once again I am repeating the name of the case. The name of the case is Darshan Garg, Hindu Undivided Family versus Assistant Commissioner of Income Tax, and this case has been reported in 113 ITR Tribunal at page number 718, and the matter has been decided by Amritsar ITAT on 1st July 2024. Thank you friends.